I'd like to welcome you to the JPI-sponsored the High Cost of Bail panel discussion. Peter Leone's my name. I'm a faculty member in the College of Ed at the University of Maryland, and I also have the privilege of serving as chair of the board of JPI. JPI is a wonderful organization. I don't know how well you know about who we are, what we do. It's a small organization that's focused on reducing society, broadly speaking, reducing society's reliance on incarceration. And so these reports that have been generated over the last several months focus on what we consider to be a very serious problem, and that is the use of money bail. So we're delighted that you're here today. We hope that this is an informative and very engaging discussion. I'd like to just acknowledge the JPI team that helped make this happen and put this together, as well as Mike and Melissa for the outstanding reports that we'll be discussing today. So again, welcome, and thank you very much for coming. Tracy?
So my name is Tracy Velázquez, and I'm the Executive Director of the Justice Policy Institute. And I also want to welcome you here to our bail event. Some of you may know that we did an event around private prisons last year that was very well attended. And after we finally recovered from that event, we decided maybe we could do an event this year. So we're excited to be talking about bail. We've never done a month around a certain event, a certain issue before. So Bail Month has been a really great opportunity to shine a light on this really not well understood part of, a very broken part of the criminal justice system. So before we get into our program, I wanted to thank the JPI staff who are here. You'll get to hear from Melissa and Spike in a minute, but this couldn't have happened without all of our small staff, as Peter mentioned. So I wanted to thank Paul Ashton, Jacqueline Kahn, Zerlene Hughes, Ajwa Masozi, Kelly Shaw, and Keith Wallington. So thank you all for your help. And also our interns have also been instrumental in making this happen. We really thank you. So in addition to Peter, there's a couple other board members in the room. Sabrina is over there. She'll be talking with you later. And our other board members include Noah Dresner, who I think I saw come in. And other board members include Catherine Huffman, Joe Tolman, so I hope you get a chance to talk to them at the end when we have refreshments, which hopefully you all got your special drink ticket, and we should have some food as well. So finally, the last thank you I have is to the Public Welfare Foundation. They have recognized the importance of improving pretrial justice, and they have supported us through this bail month, and without their support, this event and the reports we did, the three reports would not be possible. So I wanted to just let you know the format for tonight. So our four speakers will be Melissa Neal, who is a Senior Research Associate at JPI, and she is the author of Bail Fail, and she'll talk about current policies and practices around money bail, and a bit about how it contributes to jail populations. Following Melissa, Natalie Finegar, who is the Chief Attorney for the Neighborhood Defenders Northwest, which is a Baltimore City community-based client-centered division of the Maryland Office of the Public Defender. She previously served as the Chief Attorney for the OPD at Central Booking in Baltimore and supervised attorneys representing clients at bail reviews in Baltimore City. She will share her firsthand experience of Baltimore's pretrial process and how bail affects that community. Then Spike Bradford, JPI Senior Research Associate and author of For Better or For Profit, our report on for-profit bail industry, will discuss how this industry has grown with the help of giant insurance bonding companies and how it influences pretrial decision-making and policies in the U.S. And finally, Spurgeon Kennedy, who is the Director of Research and Analysis at the D.C. Pretrial Services Agency, and he is also the Vice President of the National Association for Pretrial Services. He will talk about how things are done in D.C., which is differently than they're done around the country, and can serve as an inspiration and a model for others around the country. So we appreciate you making time out of your days to come here. So I wanted to let you know that each panelist will talk for somewhere around 10 minutes, and I would like people to hold questions off until the end. And this is both to make sure they all have a chance to talk, but because the issue of bail is complicated. And I think the story can't be told until you've heard all four panelists. That will give you the clearest picture of what we see as the problems around money bail and what we see as some of the solutions. So again, thank you all for your coming. So I am going to, at this point, turn it over to Melissa, who will talk about bail fail and money bail in general.
Thank you, Tracy. I'm just really excited to be here to speak to you all about money bail. And first, want to clarify what I mean by money bail. I'm not going to assume that everyone in the room knows what I'm talking about. When someone is arrested, they typically go through a process, and in order to release people as they wait for their court date, we have a number of mechanisms in place to ensure that they return to court for their hearing, and also so that they don't pose harm to the community as they wait for their court date. Typically, what we think about is that people have to post a sum of money in order to get out of jail. What I'm going to be talking about is that we don't have to depend on money, and that traditionally we have not relied so heavily on requiring someone to put up a sum of money in order to get out of jail as they wait for their court date. First of all, I want to highlight the use of money bail and how it's increased in the past decades. The use of non-financial release mechanisms has decreased by about a third since 1992. So all of those people now are being released under financial conditions, meaning they have to post an amount of money. In 2006, the latest data that I have on this, about 70% of people were required to post some amount of money in order to get out of jail as they waited for their court date. And I remind you, they haven't been convicted yet. They're not guilty until the trial is complete. So, but they're still required to post some form of money in order to get out of jail. The second thing I want to raise about the use of money bail is that the amount of bail has increased dramatically. Between 1992 and 2006, the average amount of bail increased by $30,000. And when you look at the average amount of money that people are bringing into their homes on an annual basis, it's quite disturbing. In 2006, we saw that the annual wage compensation was about $37,000, but the average bail amount in 2006 was $55,500. So you're seeing a lot of people being assigned a bail amount that they could not even pay with their whole year's salary. As we've seen money bail amounts rise, we're also seeing the number of people detained in jail as they wait for their court date rise. In 1992, about 14% of people were detained in jail while waiting their court date. In 2006, that was up to 42% of people. The main thing that I want to raise in using money bail, or one main thing, is that it doesn't guarantee safety. Many people that advocate for the use of money bail will say that if someone has posted a sum of money and then they flee or they do not attend their court date, then the court will have the money they need to go after them. And if you think of it that way, it makes sense. But should the person actually be a high-risk person that actually could possibly pose a harm to the community, if they are able to pay their bail amount and return to the community and then harm someone, I don't think that any amount of money that the court has could remedy that. So we're advocating for less reliance on money and implementing measures that look at risk and more objectively assure safety in our community. There's also no research that shows that the use of money bail actually predicts court attendance or that a person would avoid being rearrested. There's no logistical regressions that have been done that can correlate the use of money bail and compliance in not being rearrested or attending a court hearing. So the fact that we depend on it so heavily is questionable because the science doesn't support it. The other issue with using money bail is that it does negatively affect low-income communities and minorities. What we're seeing is that someone who cannot post a money bail could end up losing their job. If they're self-employed, say they have a house cleaning business. If they are detained in jail for a week, their business is shut down. Many of them lose their housing. They may lose their apartment. If they are homeless, they lose their spot in a homeless shelter. Many of them will lose their spot in drug rehabilitation. So we're seeing many people suffering the adverse consequences of staying in jail because they cannot afford to pay a bail, but also needing to get back home and take care of their children, and we're trying to avoid that. The use of money bail also contributes to the judicial system being unjust, and what we're seeing is that there are a high rate of cases being settled through plea bargains, and in 2006, only 3% of cases went to trial. So that there were about 96% of cases that were settled through plea bargains. And what we're seeing is that many people hear the amount of bail that's set for them, and they will say, there's no way I can pay that bail. What's the easiest way for me to get out of jail so I can get back home? And they'll take a plea bargain. So we're seeing a lot of, potentially, a lot of innocent people pleading guilty. And there are studies that are suggesting that people who are trying to avoid a really adverse consequence will admit guilt when they are not guilty. And this poses a risk of harm. This is a safety concern in our communities because people who are committing the offenses remain unaccounted for, and they are not made they are not brought to justice. And this is a travesty to our victims as well, who are not seeing the people who have committed harm against them held accountable. So the last thing that I want to emphasize is that there are alternatives to money bail. There are risk assessments that we can put into place that objectively assess whether a person is likely to commit harm in the community or not attend their court hearing. And the data that risk assessments can provide are objective, and it can give judges, this data on which they can make an informed decision. So that's one option that we can use. People who may be of medium or high risk could be released safely in the community under the supervision of a pretrial service agency or under conditional release options. So there are many other recommendations that I make in my report. I welcome you to take a look at that, or please come and speak with me after the panel, and we'll move on to Natalie, and she can continue to build on this argument that I've started. Thank you.
Thank you. I found the report, the reports that we have in front of us this evening to be very enlightening, and also just highlight what my everyday experience is. I have some figures that pertain to Baltimore, but most of what I'm going to speak about tonight is just what I see every day as a practicing public defender and having practiced for the past 19 years now. Judges, when you go before them in Baltimore City, have a tendency to set a higher bail than any other jurisdiction in Maryland, in Baltimore City, despite the fact that their conviction rate is actually one of the lowest in the state. So what you have is a situation where judges insist that they have to assume that what is in the statement of probable cause and the top count, that is the most serious offense that somebody is charged with, is what should be considered as part of the risk to public safety and what an appropriate bail, if any, is to be set. But the reality is, if you look at a 2008 report by the Able Foundation, you find that in Baltimore City, only 71% of all jury trials in Baltimore City results it's 71% results in acquittal of the top charge. So what you have is a situation where the vast majority of folks in Baltimore City who go to trial, who actually wait it out in jail or under the financial strain of posting a money bail, that very few of them are actually acquitted of that top count that the judge considered to begin with in making that bail determination. You also have a situation where in 2012, the state's attorney's office has published the figure that they've dismissed 20% of all felonies. In Baltimore City, for a felony to actually go to trial, it can take close to a year frequently. So you can wait out an entire year in jail or under the financial strain of high bail, and 20% of those folks will have their case dismissed entirely. Kind of an oops by the prosecutor at that point. We shouldn't have charged you. We can't prove this case. My clients in Baltimore, when I represent them on at bail reviews, and we try to present all the information we can to the judge at the time, ask for re-reviews, modifications of bails, are faced with a very terrible circumstance of staying in jail or trying to get money together to use a bail bondsman. In Maryland, 10% is required as a payment, but bail bondsmen will take 1%. And so I find myself on the phone with grandmothers and mothers, begging them to try to scrape together that 1% of bail, and then they owe the other 9%. And part of me feels guilty, because I know what a financial strain that is for the family to have to continue the payments to the bail bondsman. And yet, I also know that my client is physically at risk staying in jail. So we do it as public defenders. But there's got to be a better way. I'll tell you, in the past 10 years that I've been practicing, it may have been longer, but I can guarantee you it's in the past 10 years, I've never seen a bail bondsman come to court. There's summons for every case, but I have never seen one come to court when they have a bailee present. I also very rarely have seen or heard in court documents, when I pour through them, bail actually being forfeited when somebody fails to appear. What I have seen is when a family member posts bail, they have a tendency to show up in court. And they have a tendency to say, am I going to get my $500 back? So in terms of assurance of who's going to show up, I guess a good question is, are the folks who are going to show up essentially the folks that are part of an insurance industry, or are they the family members of my clients, indigent defendants, for whom $500 is a world to them? Family members that use bail bondsmen and scrape together that 1% have caused a great deal of instability in their families frequently. And it's been my experience in talking to clients that actually posting that bail money makes it less likely in some circumstances that they show up for court. What they tell me when I represent them and they fail to appear is that so-and-so posted the bail money in the family. And then there wasn't a way for me to get to court because I was going to have to take 5 buses. And by the time I got there, I was late. And what you have to understand is in Baltimore, some judges issue bench warrants 20 minutes after the start of the docket. So it's really, really crucial that our clients be there exactly on time, if not ahead of the trial date. And so if you're taking that money and causing those payment plans to be enforced with our family members, what you're having is you're destabilizing the whole family. Because the reality is that it doesn't come automatically that my clients get bailed out, even when the family members can get the money together. It might take 4, 5, 10 days, and by that time my client's probably lost his job if he had it, or somebody else has missed significant work time so that they can't take that day off to drive the client to court. I think that we need to rethink the system, and I think that we need to also recognize that it would be more effective for us to get involved early with these folks that are charged with crimes, many of them who will never be convicted, but nonetheless face some significant mental health and health issues, drug addiction, and that we should instead be concentrating resources on trying to stabilize their life, rather than extracting money from them that's going to cause further destabilization. In my practice and in a holistic setting, we get early intervention with our clients. One of the simplest things we've done is actually sent a letter out to remind them of their trial date. And anecdotally, that looks like that's reducing the overall failure to appear rate in the 20% or so from other jurisdictions in Baltimore City, other courtrooms that we practice in. And also we get our clients linked with drug treatment early on. And they're more likely to show up for court, A, when they're sober, and B, when they have a sense that things might go their way. I'm doing well in treatment. The judge has a possibility of giving me a shot. And I think that it would be better to concentrate resources with a pretrial services agent for many of these folks, rather than concentrating our kind of system on bail, where I have yet to actually encounter a bail bondsman that's made a lot of referrals for treatment. It's just not their business, and it's fine that it's not their business. I'd also like to just leave you with this final note. In my practice at Central Booking, I was there at the time as the chief attorney when we had over 100,000 arrests in Baltimore City. We had a zero tolerance policy in Baltimore. And we talk a lot about safety and holding people in jail for safety's sake, but I think we need to think about safety inside of our prisons when they're overcrowded. Because in 2005, in that exactly overcrowded situation where correctional officers were completely overwhelmed, we had an individual by the name of Raymond Smoots, who was allegedly, and these folks did eventually plead guilty, beaten to death by correctional officers. And Mr. Smoots was incarcerated for a misdemeanor drug charge on $100 bail. So really we need to be looking at who's in prison, why they're there, and whether or not that really is producing safety for all of us.
Thank you. Get my volume modulation right here. Thank you. That was a very interesting perspective, and one that I was glad to hear. And thank you all for coming here today. My task was to examine the for-profit bail bonding industry as part of the pretrial criminal justice system in the U.S. And I found a number of things that were surprising and a number of things that were shocking to me, quite frankly. First, I found that the U.S. and the Philippines are the only two countries in the world that use the for-profit bail bonding model. And in a lot of countries, the idea of paying someone to post a bond for you would be considered an obstruction of justice. But it's sort of status quo here in a lot of places in the U.S. I also found that for-profit bail bonding is an insurance business, and it's really an anomaly within a system that is necessarily government-initiated and government-controlled. And by ceding control over that part of the process in the pretrial stage, it really causes a lot of harm throughout the whole system. Now, I also found that, in contrast to media stereotypes, bail bondsmen and women are typically upstanding, decent folks who really care about the work that they do and really care about the role that they play in the lives of people who've been arrested. However, the industry in which they work, the for-profit bail bonding industry, is exactly that. It's for-profit. And as such, it doesn't meet the numerous other motives that a holistic criminal justice process requires. For example, public safety, treatment and intervention, and positive social and community outcomes. So in the report, which you have the executive summary in your seat folders, I covered some of the main weaknesses of the for-profit model, some of which I will go over briefly here. First, it's a highly profitable business whose primary customers are low-income people who have been arrested. I don't think it's any stretch to consider this a vulnerable community. And bail bonding charges them a steep fee for little to no services rendered. The primary business decision of a for-profit bail bondsman is financial. Can you, or more often your family, pay for the bail bond premium, and can they pay the full bail amount if you fail to show up in court? It doesn't consider dangerousness. It doesn't consider the risk of rearrest during pretrial release. It also fails to recognize the plight of people who can't afford even the bail bond. And if I might interject with a little anecdote, I was reading a book from a very famous bail bondsman last night, and the scene in which he meets his wife, he's called down to the jail to actually write a bail bond for her. And he says in the book, I'm not sure why I went, because generally her bond was too low for me to go. She had been caught shoplifting a lemon, I believe. So she had a very small bail bond that normally he would not have gone to write. So those people, you're at the whim of the bail bondsman if you have a low bond. We'll hand it over. There are absolutely no repercussions for a bail bondsman if their client is rearrested during release. And in fact, one could argue that if they are rearrested, the risk of flight for that client is eliminated, and it's a good scenario for the bail bondsman. In spite of claims that the entire for-profit bail model is based on the threat of a bondsman having to pay forfeitures to the court, and that is the full bail amount if their client fails to show up for court. This is really an empty risk. They are given extreme conditions in which they can delay or nullify the forfeitures, and the process is costly and complex for the court, so often millions of dollars in forfeitures around the country have gone uncollected. There are places in which bail bonding is unregulated or underregulated, and this leaves judges to guess exactly, I think you were saying 1% in Baltimore sometimes, exactly how much a person is going to have to pay to get out of jail pre-trial. Is it 10% of the full bail? Is it 2%? Some cases 1%. And this causes judges then and magistrates to raise bail amounts to levels that are inaccessible to a lot of people. So the real question of all these findings I have, the real question that I had then was if we know all of this and we know that there are viable alternatives, namely pretrial services agencies like Melissa mentioned, who perform risk assessments on arrested people, make a recommendation to the court about how to handle their pretrial situation, and in many places supervise and monitor conditions of pretrial release. And we know that these things exist. And when we take all the voices that have come out in support of reform, I will list just a few. American Probation and Parole Association, several federal and state attorneys general, American Bar Association, International Association of Chiefs of Police, American Jail Association, Association of Prosecuting Attorneys, American Council of Chief Defenders, many, many, many more people who have come out in support of pretrial reform. Why do we still have for-profit bail bonding? Well, the way I look at it is this. An arrested person often has to pay money to get out of jail before trial. The for-profit bail bonding industry pays money to stay in the game. And they do this through lobbying. They hire lobbyists around the country to promote lax regulations. They do it through campaign donations to state legislators, which are significant. And they do it through an association between professional associations, namely American Bail Coalition and ALEC, the American Legislative Exchange Council. Together, those two groups, in the 10 years following their partnership in 1994, put together about a dozen bail-friendly bills that they pushed out to the states, which simultaneously seek to raise the profits of the industry while harming and defunding pretrial services agencies. So what can we do about this? Well, I give a couple recommendations. The first one is we should eliminate for-profit bail bonding. I know that's an extreme position, and this is it's harmful, it's antiquated, we should get rid of it. The second recommendation is that we should support and create pretrial services agencies, support them where they exist, create them where they don't, give them the political support they need, which involves resisting the money of the bail industry and the empty arguments of the bail industry. And the final recommendation is that because this can't be achieved overnight, before we can eliminate the practice, we need to require greater transparency and better reporting from within the industry. We need to know who they bond, why they bond them, why they don't bond them, how much they bond them for. We need to know all the information about forfeitures and exonerations and all of these things that, because it is a private industry, we don't really have clarity on. And doing this is just part of the larger goal of taking money out of the pretrial system and putting it all right back in the courts where it belongs. Thank you.
Good afternoon. If you've read the JPI documents, then you know that if you are an advocate of the financial bonding system, you have one really good argument, right? We need that financial incentive to get people in court. Okay? We need money because money is the motivator. It makes you do the things you're supposed to do. I need that financial incentive to get back in court. If that's true, then what we're seeing here, those inequities and everything else, it's unfortunate, but it's necessary to do good business. Here's the problem if you're an advocate. That simply isn't true. Every day around this country, in courts from Washington, D.C., to Kentucky, to Oregon, to Florida, thousands of defendants come back to court the way that they're supposed to. Thousands of defendants with pending appearances remain arrest-free. They don't get into trouble again. And they do this while being released on the promise to come back to court or on conditions of supervision. No money. There's that financial incentive not hanging over my head. If you follow where the research tells you to go, if you look at where the facts are telling you to go, you will find that that central argument, that we need that financial incentive, is antiquated, it's wrong. And the system that it supports cannot be defensible. It simply cannot be. There's no good reason in this day and age, knowing what we know about criminal justice, knowing what we know about the people who come through our doors, that we are still using money as a means of release and detention. The outsourcing of a judicial decision to private bail interest is wrong. And there's more than enough proof out there that there are better ways, more efficient ways, more fair ways to make this work. In Washington, D.C., 88% of the defendants who have cases pending before our Superior Court get released non-financially, either in the promise to appear or on conditions of supervision. Money isn't used here. In the very rare cases where money is used, I'm talking rare, less than 4% of the cases here locally, the money bond that is used most often is the cash bond. Bail bondsmen aren't here. We don't need them here. Judges have said long ago that I don't need that third party with that financial incentive to make anyone do what they're supposed to do. We have a system where a person's promise to appear, often conditioned with supervisions designed to minimize the risk of failure to appear and safety, is the rule. It's not the exception. Here, liberty is the thing that we strive for. And when detention does happen, and we do have people, believe me, who deserve to be in jail while their cases are pending. Sorry, Mr. Attorney. There is a better way besides throwing a money amount and hoping that they don't catch it. We have laws in effect that outline defendants who are eligible for detention. They give that person a due process protection against detention, and they work. Right now, there are only about 12% of pretrial defendants who are detained throughout their court cases. And they're detained because, by law, they're identified as risk to the community, not because they don't have the money to make bail. Now, this didn't happen overnight. We didn't wave a magic wand and all of a sudden have a system of bail that is fair and equitable, not just to the people who go through the system, but to the public that needs to be assured of safety while these cases are pending. It took a while. And at some point, honestly, our laws were coexisting. We had a great pretrial agency working right alongside bail bondsmen. At some point, though, we developed a culture here that simply looked at money and said, why are we doing this? We added language in our bail law that restricted the court from using money to detain defendants. Plain and simple. You cannot use money for preventive detention. And a funny thing happened. Judges stopped using money for preventive detention. They started using the statute. The sky didn't fall. People didn't start coming out of courts and running away. The system continued to work. Because when you look at the evidence again, if you go where the evidence tells you to go, you will find that most defendants in our criminal justice systems don't present a high risk of failure. Most of the people who get assessed for pretrial release are low to medium probabilities of missing court appearances and being rearrested. They don't need the financial incentive to get them into court. What they need, simply, in most cases, as we said before, are very minimal to medium levels of supervision. Everything from being notified of an ex-court appearance to reporting weekly to a case manager. If you have that mechanism in effect, you have the answer to most pretrial risks that you see in your local communities. So what do you need? What do we have locally in Washington that makes this thing work? First off, and most importantly, we have a model bail statute. We have a statute that says specifically that any defendant who comes before that court is going to be released on their promise to come to court unless their risk of failure, of missing a court appearance or being rearrested is too great. The next step is conditional supervision. The next step is outright detention. We have a bail law that presumes release. We also have a bail law that understands that you have to have an alternative to money for those persons who are too risky to be released pre-trial. We have preventive detention in our statute. It is set for a very small, very well-defined population. There are due process protections in the law, and it works. You also need to have an effective way of assessing risk. You need to have a program that can get information, background information about the defendants who come through your court system, and make good, solid recommendations to the court about what this person needs. If you do that, you will find that the vast majority of defendants don't need high levels of money, they don't need high levels of supervision, they simply need monitoring to medium-level supervision. You have to put that supervision in place to make that risk assessment work. You have to have a variety of supervision options available so that judges have the options to use, the right options to use, to place the right defendant under the right supervision. We've been doing this. It isn't perfect. We still are making mistakes along the way. But if you look at the bail system in Washington, we have managed to take away the lie that money is essential and necessary to a bail system. What you need is the truth. If you follow the truth, you'll get it. Thank you.
All right, well, so now it's your turn to ask questions. I have a wireless mic, and hopefully I have a JPI staff person who's going to walk around with it. Paul. Go, Paul. So if you have a question for our panel, raise your hand, and Paul will get you the mic so everyone else can hear your question.
I'd like to ask you about your public defender caseload in Baltimore. A lot of research over the last 50 years has shown rather conclusively that defendants who are held pre-trial get far worse plea offers and sentences than virtual identical defendant who's out. Is that your experience? And would you talk about that?
It absolutely is my experience. If we have a client who's out on the street, they have a much greater likelihood of staying on the street, the outcome of their case. I mean, as was discussed before, most cases are resolved through plea bargains. When we have a client who's on the street and they manage to do well on the street with a little bit of support that either our office, pretrial, or somebody else might be providing them, or just on their own that they may get, then you have a demonstrated capability of being in the community, and it's a better argument for probation. Folks that are incarcerated, there's a higher tendency to do either time served or tack a little bit extra on so that we're not, just slapping them on the wrist. And so it is a world of a difference for a client to be out on bail, not just for themselves, but for their family, for their children, for the stability of the whole community.
Thank you guys so much. This is really interesting. I didn't mean to brunch Ms. Finegar with questions, so I have a question for you, of course. My question is, I'm assuming that the public defenders and the rest of us don't have as much money right now as the bail bondsmen to do lobbying, and so these laws might not change tomorrow. What can public defenders and other folks do, maybe this is for everybody, what can public defenders and other people do right now to try and help reduce the number of people who are getting money bail for getting released from jail?
I think what the public defenders need to do, in particular, and I guess I'll just speak for us, is we need to just be hammering down on this issue and making sure that bail reviews and initial bail hearings are done with as much meaning as possible. And a good example of this would be, we had a special unit revamped in our office recently to deal with youthful defenders. These are juveniles charged as adults, and we could have a whole separate forum on whether or not that makes sense, right? But they are. And the question was where they should be housed. Should they be housed with the adults or be housed with the juveniles? And the time that it gets decided is at the bail review, frequently. And there was a lot of discussion about you can't possibly convince these judges and change their attitudes. They're used to housing them with adults. But with bringing a lot of studies, the information we have forward here, highlighting it to the judges, bench conferences with the judges, highlighting successes, highlighting failures by continuing to doing things the same way that they've been doing it. Slowly but surely, at least 50% of those kids are now transferred back to juvenile facilities in Baltimore. And so I think that's what we need to do. And I guess it's kind of painful because our caseloads are crushing. But we are in the process of Baltimore, in the Public Defender's Office of demanding, this is kind of shocking, private interview space for our clients. What a shocking idea that I should be able to talk to my client by myself with them for 15 minutes before a bail review. And that's where we are. That's the reality of where we are in the Public Defender's Office. And we need that 15 minutes plus probably more, but that's what we're going to get from public safety for now.
I wanted to follow up on who the champions were when DC started to shift away. Were there other voices besides public defenders to help make it happen?
We've been very fortunate in Washington that nearly all of our criminal justice partners have supported our pretrial reform efforts. Everyone from our court to public defenders, even to our prosecuting attorneys through the U.S. Attorney's Office. Primarily, if you're looking for one person, and there always is that one person, Jay Carver, our former director of pretrial services, really led the way in having the laws changed. But when you do that, you really need to look around the room and find people who are willing to stand up with you. And when that happened way back in 1992, there were a lot of people there, our chief judges, our U.S. attorneys, and our public defenders. And that happens when your system understands that you have something in place that works. And if you can show them through data, if you can show them through just the everyday, anecdotal evidence sometimes that people are coming back, you do get that support.
I too want to thank JPI for having this great panel discussion on money bail. And I guess I'll start off with saying that I too am an advocate to get rid of money bail for a number of other reasons. Simply because the people that are being arrested and incarcerated in this country, the socioeconomic index for those folks are very devastating, and they contribute to a lot of the mass incarceration and this old capitalist perspective that our prison system has taken over the last 150 years. With that being said, though, I do want to put a plug in, hope give an option of looking at money bail through a different lens as far as the bail bond perspective is concerned. We continuously hear about the poverty that most folks arrested in this country are facing, and we even had the public defender here from Baltimore says that they charge a nominal 10% for bail fees. But you also have the second part of the conversation is that the bail bondsmen are willing to take 1% of the 10% and allow folks to have a payment plan. We can all imagine, and we can all point the finger, but we can all imagine if those bail bondsmen didn't exist, then whom would take that 1% and allow a payment plan? And I know from my research and my experiences that the court is not going to give a payment plan. There's a 10% deposit there that is used in some jurisdictions, and that entire 10% has to be paid to the court before anyone is allowed to be released. And that's regardless of the socioeconomic index not being included in this conversation. So I would like to ask to consider some part of this conversation is saying, well, the judiciary that are making these recommendations and decisions, how much responsibility lies with the judges and the magistrates for setting what we will call and defined in the Eighth Amendment as excessive, and how we actually operationalize excessive from the perspective of the judiciary. The bail bondsmen aren't setting the bail. It's the courtroom that's setting bail, the judge. And we kind of leave that out of the conversation whenever money bail comes up. Secondly, just another plug for the bail bondsmen. Some feel as often as that they're doing a community service. I've had people come and express, without you, my baby never would have been home to eat Thanksgiving dinner. Not having those funds is very important. And when you're in that space and you have that judicial authority to go post bail and take less money or take no money on a promise, I'm not sure how many people would be willing to do that other than folks that are actually in that space understanding what happens. Third part of what I want to say is DC, great, 88%, amazing. With that being said, I'm curious to know why hasn't that model taken place in other jurisdictions? We have the research here. Your jurisdiction compared to Philadelphia, 60%, Atlanta, about 70% are offering non-financial bail, 40% non-financial, 60% financial. This model is reducing FTA, failure to appeal. That's the first purpose of what bail is supposed to be about. Not accessing danger to the community, not the responsibility. Again, the responsibility of the court and work with the judiciary. And my research and experience, 2 minutes and 19 seconds and 2 minutes and 40 seconds in open court isn't that much time to make an assessment on whether or not someone should deserve to be released back into the community. So I just want to share some light on maybe a couple of different lenses that we have left out from the conversation when we're actually talking about money bail and who it actually impacts.
Great, thanks. It's nice to see you again. I will make one or two comments, and then I think maybe you reaching for the mic as well. Guess what I would do if I got arrested at home in Montgomery County tonight and my bail was $100,000? I called bail bondsman, okay? And I just called for the elimination of the bail bond industry. But the way things stand and the fact that somebody would set a $100,000 bail on me is indicative of the system and the problem that we have in the system. As I mentioned, we can't get rid of for-profit bail overnight. And as you mentioned, in the transition to the system that DC has, there was a period of time in which the two coexisted with each other. And so, yes, bail bondsmen do serve a purpose in our current system. And yes, I know they are out there trying to help people who can't come up with 10%. From a holistic sense, in my mind, the whole thing is flawed. And it is hard to throw out the bathwater. But we can start spooning it out, I think, slowly. Spurgeon, you want to say?
Sure. First off, I applaud your philanthropy. But here's my problem. It doesn't matter if you're giving 10%, 1%, 2%, you shouldn't be getting anything at all. The main premise here is that money isn't needed. And as great as you are and as much as you're working with people, you're still at a level that you shouldn't be. That person should not have to come to you if there's enough evidence, and believe me there is, that says release them without your help, sometimes without my agency's help. But that argument that we do better because we ask for less, or now we're in a credit plan, great, wonderful, not needed. As far as DC model and where it is, don't be too sure that it hasn't been replicated in other places. There are jurisdictions across the country. The state of Kentucky has a statewide pretrial program. They outlaw commercial surety bail. States like Wisconsin and Oregon, they have laws. Illinois, they have laws in effect that reduce the use of commercial surety near zero. They don't all have the same release, PR, supervision model that we do, but there is a lot of reform that has been happening over the last 50 years that is making the whole idea of money obsolete and hopefully eliminates it altogether.
If I may add, I think that one reason that the models have not been expanded, trial services have not been expanded to other jurisdictions, is the influence of the for-profit bail bonding industry in promoting model bills to state legislators and so forth that actually push for the use of bail bondsmen and reduce our ability to focus on pretrial services and other effective non-financial release options.
Hello, everyone. I just want to give a small little anecdotal story about how once the for-profit bail system proliferates, how terrible it can be. So imagine anyone from D.C. going away. This just happened to me 3 weeks ago. Went to Miami for Labor Day. Unfortunately, my cousin, because in some parts of Miami, I swear that you can't be from anywhere else other than Cuba or something. They automatically think that you're doing something wrong. So my cousin was detained. They set a $25,000 bail. And now, he would have gone back to court either way. Now, we have to scrape up money because we have to pay for this outrageous bail for him doing nothing wrong. To go back down, get this case, which is going to be dismissed, we have to scrape up money so he can fly back to Miami now to go be able to go to court. Now, this is a deterrent from going to court if you don't have money to get back to wherever you were, where they have these outrageous for-profit bail industry. So I just wanted to highlight that it could definitely be a deterrent to going back if you happen to find yourself in a situation like that. So the high bail prices and people having to try to find these expenses, trying to find the money to pay these type of expenses can actually do the opposite of guaranteeing that you come back to court if you can't make it because of it.
I have a question and then I have a comment. My first question is, was there any statistical work done on people that have been released on a pretrial or no money bail? How often or how many of them do not come back to court? And how long does it take before those people are found and brought back to court? Has there been any, you guys have any statistics on that?
Well, as I mentioned locally in Washington, those defendants who are released non-financially, that is those on either the personal recognizance or promise to appear or conditional supervision, 88% make all scheduled court appearances, 88% remain arrest-free while they're out. That is a population of about 88% of defendants total who get released. There are other individual statistics nationwide that show that pretrial releases, persons on non-financial release, do have high rates of successful outcomes. So if you're looking for numbers, we certainly have.
Okay, and do you have any for nationwide or that? Because that's very commendable for DC to have that rate. Very commendable. What about nationwide?
If you leave your information with Bill, you have to give it to you.
Okay, and then my comment as well is I am a bail agent, and I'm here because I wanted to stand and let you guys know that we are partners in the criminal justice system. And I was happy to hear Mr. Bradford say that a lot of the women that are in bail bonds do work. For me, I am a small business owner, but I also work to help individuals get resources for jobs, mental health treatment, as well as religious support. And I just wanted to bring another perspective. A lot of the information that was given here, I agree with, and as a bail agent, I can stand here and say that, yes, I saw a lot of bad actors in my industry. And I am one that is working to educate and let these sponsors know why we have such a bad name. Because we are supposed to be a support to the criminal justice system, not just look for money gain. But as you guys are thinking, I would like to see if there's a way we could partner, because there's education needed, in my opinion, on both ends. More bondsmen should be here to hear how the bad practices that some of them are doing is causing others to feel about us. And I also feel like that if there was a partnership involved, then you guys will be able to see, wow, we didn't know that there are some bondsmen that just don't do this for money gain. I've spent many nights talking to people that I posted on, helping them not to commit suicide. I didn't get paid for that. But because I know where I came from, and being a person that worked in the criminal justice system before I became a bondsman, that was something that was dear to me. So it's a passion. So I'm coming here today to be educated, as well as wanted to let you know that there are some bondsmen that would like to partner and learn how we can work together, and that we're all not just for money gain. Thank you.
So I'm going to have one more question, and then all of our panelists are sticking around, and you can visit with them individually and do it with refreshing beverages and food. food in your hand. So our last question of the night, and then we're going to turn over to Sabrina, my another board member, to wrap up.
I'm Mary Frances Smith. I'm from Toledo, Ohio. I've been in the bail bond industry since 1989. I have 38 people that currently depend on me on a daily basis. I've seen your research, but I'd like to talk to you about what we really do. One example is Sarah Heath. Sarah is a 25-year-old woman who has 3 children. Sarah lost her children to her mother because she didn't graduate high school and couldn't find work. The relationships became rocky, and because a fight ensued, Sarah was arrested for domestic violence. The judge told Sarah she would have to attend and pay for anger management classes, alcohol assessments prior to conviction. Sarah became overwhelmed at the cost to her that she still could not afford. She did not complete the courses, so Sarah failed to appear in court. We were hired. $25,000 bond. Sarah, bond forfeiture, notice because she still couldn't complete the courses that pretrial services had set, was issued and a show cause was set. After finding Sarah, we paid for a round-trip ticket for her to ride the bus back to Ohio. Met her at the bus stop at 6 a.m., took her to breakfast, took her to my home so that she could shower, and then to court. Stood next to her, and the judge reinstated her bond. She is currently still trying to afford the classes while working at a restaurant, but she will be in court, and no taxpayers are affected by this. I will say that there are things that the pretrial services have come up a little short, but I'm not going to continue that today because the personal risk for us who are liable go beyond the scope of a greedy business persona. We work endlessly and tirelessly to help the defendant while allowing the victim their rights to have their cases heard in court. If you work to eliminate our industry, there will be thousands of agents, office staff, supporting vendors out of work. This country does not need more citizens on an unemployment line. Ladies and gentlemen, we would love to work with you to better the system for both of us instead of working against each other. Thank you.
I don't think anybody's here saying that every bail bondsman person out there in the world is evil and that people haven't done incredible things for folks that are essentially my client base, although I don't practice in Ohio. But I guess the question is, do we want to envision a world where folks pay out of their pocket and then they can't afford their anger management classes to get on bail? Or do we want to direct our resources away from people being incarcerated that shouldn't be incarcerated, fund stronger pretrial services that where anger management classes wouldn't cost them money, and support them to get to court? And I guess, there's 2 different worlds to envision there. And I'd like to see us directing the resources where I have less clients in the future because folks have more stability in their lives. Thank you.
First off, welcome. Toledo's a long way from here. You made a point, and I totally agree with you. Anger management, other conditions of supervision. Do we sometimes overdo it when it comes to supervision? You bet. And one of the issues affecting my field is sometimes, and you bring up a great case, the need to put conditions on simply because we think conditions need to be placed on. Don't get me started about anger management in trial. It's silly, it shouldn't happen, your client shouldn't have it as condition of supervision pre-trial. I have to wonder then, and you and I can talk about this and go back. Again, if that bond hadn't been set in the first place, if your client has simply been released on his or her promise to come to court or on conditions that were reasonable, whether or not they would have needed your help, whether or not they would have needed my program's help or the Toledo program's help. Again, it comes back to not what we're trying to do and who's right and who's doing the right thing. It's what's needed. And for most people, that system isn't needed. And that's the point that I want to bring out.
I think I wanted to add that although there are individuals in the world who do provide wonderful service and have hearts to help people, what we're trying to address is just the overall impact of how money bail is hurting communities and families that have to scrape up the money to pay a bail bondsman, and they're not able to pay their rent or pay for substance abuse treatment or so forth. So, we're trying to look at the various ways that money bail adversely impacts us. How many people are innocent and being guilty because they can't afford to pay the bail? Those are the kind of things that need to be addressed. These are the reasons why I'm opposing money bail and advocating for very effective, very cost-effective, evidence-based practices that we can implement that do not involve money.
Well, I'm going to turn this over to Sabrina Wood, who is treasurer of JPI, who has a very important message for you before we turn you loose.
Good evening, everyone. Again, my name is Sabrina Wood, and I want to thank you all for coming out tonight. This has been a really great panel, a lot of information. And I joined the JPI board as a CPA and an accountant that specializes in nonprofits. And so I see things from after the fact and behind the lines. And this was my chance to get involved and do a little something so that whatever I'm doing for JPI allows people to go ahead and make this research happen and make these things happen. So what I want to do tonight is, again, thank you for coming. On your seats, you have a packet. It has a few materials in it. If you don't have a packet, please raise your hand, and one of the JPI staff will get a packet out to you. Inside that packet, we have 2 summaries of 3 of our reports. If you want a full copy of the report, you are able to get it on the website, okay? And the website is jpi.justicepolicy.org, okay? JusticePolicyInstitute.org if you want to get the full report. And then, most important, as I just stated, sometimes what you want to do is help the people who are on the line. And in that vein, I'd love you to also look in that packet and see that we have a donation card. So if you really enjoyed this program tonight and you want to do something to help the people that are on the front line trying to get these things changed, trying to get some people some help, please feel free to go ahead and put a donation in of $50. That will really help our cause and let JPI continue the work we're doing with research and outreach in these really, really important subjects. So, on that note, I want to thank our panel for being here tonight. It was really interesting.